These truly are interesting times, and one of the most interesting issues is the interplay between the Supreme Court, which is noted to be very business-friendly and business-oriented, but sometimes those decisions don't seem to filter down to our regulators at FINRA or the SEC. And one of those issues is the interplay between class action waivers and mandatory arbitration provisions. Speaking on that topic today is our first speaker, Scott O'Connell. Scott is the Deputy Chair of Nixon Peabody's Litigation Department, Practice Group Leader of the firm's Commercial Litigation Team, and Practice Group Leader of the firm's Class Action and Aggregate Litigation Team. Scott represents integrated financial services companies, including banks, securities firms, insurance companies, and regulated subsidiaries of non-financial parents. Scott has extensive experience defending financial institutions in class actions concerning lender liability, breach of contract, fiduciary duty, good faith, unfair and deceptive trade practices, fraud, misrepresentation, fair debt collection practices, and civil RICO. Please welcome Scott O'Connell.
Thank you, Larry. Good morning. The last thing that a room full of New Yorkers wants to do is hear from a guy from Boston, especially this time of year, especially this year. But let me just say, we're all going to miss in the world's greatest rivalry, Mariano Rivera. And with that, let me get to the point at hand. The Supreme Court in the past 3 years has changed completely the face of class actions in America. It is a new day for all of us who have to deal with high exposure, business disruptive claims in a class or aggregate form. They're a problem, we know. Every one of you is managing some level of class action interruption. And not only can they have huge exposure, but the problem is often they go right to the business practices that your clients need to implement. And you need to stop that exposure, you need to give them solutions, and you all know better than the outside lawyers how complicated it is to roll out new practices within your firm. So these are real problems. And the fact that the Supreme Court for the past 3 terms has taken on very actively a close look at class actions, the practice, the procedure, and the way you defend against those claims has really given tools to all of us to get this overbroad, scurrilous thing under control. So I'm going to run through this term and then get back to the issue of class action waivers because, as I said at the beginning, it is a new day for those, and we should talk about what you all might want to consider to get class actions out of court and into an arbitrable form. First case that I want to mention is the Knowles case of this past term. This is important because it made clear that the creativity of plaintiffs' lawyers is bounded by the law. We all know that since 2005, CAFA has been the mechanism by which we get out of state judicial hellholes and places where class actions had run amok during the last decade. And the threshold of $5 million makes it, with certain other criteria, a way to get to federal court. Well, creative plaintiffs' lawyers said, we'll just stipulate the damages that are below $5 million. And that became a way, a gambit, to keep things from being removed. The Supreme Court made clear you can't do that. Why can't you do that? Because it's an uncertified class, and a stipulation by counsel in an uncertified class cannot bind the absent members. So I bet you on all of your dockets, there's a case that looks and feels like this. So I hope you can go back and look at it and say, oh my God, we had an improper effort to remand back to state court. Any type of stipulation or statement in the pleadings by plaintiff's counsel is a nullity. And that's a big help for all of us who want to get to a forum where we think we're going to get better justice, better review of these challenging and high exposure cases. The Genesis Healthcare Corporation case is in that subset of class actions, really collective actions in the Fair Labor Standards Act arena. And this is interesting because it does kind of cut across the strategies that all of us try and employ by limiting the size of a class. And for a long time, it's been the effort of defense counsel to try and buy the peace of a plaintiff before something gets certified. And all kinds of law under Rule 23 has developed around whether it's appropriate or not. And in a collective action, the wage and hour arena is a subspecies. It's an elect-in class. And there was this kind of wonky issue as to whether you could buy the peace and make moot the claim by extending a Rule 68 offer of judgment. And so that's been percolating around the circuits. There's a division. It gets to the Supreme Court. The Supreme Court decides the case, but not on that issue. They basically say, for a whole bunch of reasons that are unique to this case, the offer of judgment that was not accepted isn't ripe for a decision. But the reason I pause here is the world's best diss of this Supreme Court came from Justice Kagan in her dissent. Smackdown of the Third Circuit. So a friendly suggestion of the Third Circuit: rethink your mootness by unaccepted offer theory. And a note to all other courts of appeals: don't try this at home. So message is, if you're trying to buy the peace in a fair FLSA matter, be careful, because the Supreme Court is signaling, even through the dissent and some commentary in the majority, that's going to be a problem. So think of another strategy. Amgen happens in the securities class action arena. Fraud on the market is the theory that allows you to get essentially past the issue of independent reliance, because the efficient market is presumed to take any material information into account at the time of trading, and so the damages get baked into the cost of the security that's traded. What happened in this case is that the Supreme Court did something that I would view as a little bit of a setback for the defense bar, and it said that materiality cannot be challenged at the time you try and certify the class. Now, many of us used the certification process as a way to try and defeat this thing from proceeding in an aggregate form as a class action. So we would do mini trials over the issue of predominance. And if you had facty-like issues of causation and reliance, that was gold for the defense bar to try and make a claim that this is not a certifiable class. But the Supreme Court said, with regard to materiality, that is an essential element that the plaintiffs have to prove at trial. And because of that, we're going to roll the decision as to whether they meet their burden by a preponderance of the evidence until trial. Well, all of a sudden, this great arrow in our quiver is now gone, and we can't challenge it. So you now can get a class certified, and you really roll to the trial on the merits, whether the statement was material or immaterial. And so many cases turn, securities class actions turn on that. So a little bit of a bump in the road for those of us who are trying to look for ways to manage class actions. And now we get to the areas of arbitration and whether or not waivers will be enforced by their terms. Oxford Health Plans was an interesting case, and it's a cautionary tale, and we'll talk about this a little bit more before I conclude, that everybody needs to go back and look at your arbitration clauses and class waivers. Here's the problem. In Sutter, the construction of the arbitration provision was vested with the arbitrator. And everyone's clause is different. Sometimes they specify that the arbitrator is going to make those determinations. Sometimes it says the court. But here, the arbitrator was vested with the authority to do the construction, and the construction was whether or not the parties had agreed to a class proceeding in arbitration. And the arbitrator read the contract and said, I believe it was the intention of the parties to allow for class arbitration. Now, we could have a whole discussion about whether class arbitration is a good thing without any of the protections of Rule 23. That's not what we're here to talk about. I would posit, most of my clients anyway say, that's the world's worst circumstance, because you get none of the protections of Rule 23, none of the oversight of a federal judge, and it can really run amok. But the arbitrator did that construction, and it went up on review to the Supreme Court, and they said, had we gotten this question as an issue of law, contract law, by a judge, and we reviewed it de novo, we may have concluded that there was not an express provision to allow for class arbitration. And that goes back 3 terms to the Stolt-Nielsen case, where the Supreme Court said that there's got to be an unambiguous agreement to provide for this in arbitration in order for it to stick. But because it was the decision of an arbitrator, and the FAA accords enormous deference to an arbitrator's decision, all of a sudden the standard of review was completely different. And as long as there was a rational construction, they were not going to review it de novo. So you had this interesting circumstance where the court was saying, I think we would have decided this differently, but because it's happening in arbitration and because that standard is so high, we're not going to overturn it. So that's the practice pointer. Go back and figure out who is deciding the scope of your waivers. And the biggest case of last term, which I think has the most impact on this issue, was the American Express, the so-called Amex 3 case. For a long time, a way that plaintiffs would challenge the applicability of arbitration clauses was to argue that forcing things into that forum could constitute a vindication of rights exception to the FAA. Stated another way, you can't force a party into arbitration, even if there's an agreement, if they would be foregoing some state substantive rights. And it often would come up in the context of some states' unfair and deceptive trade practices law, or some statutory scheme that provided for special relief. The Supreme Court squarely closed the door on that claim. It said, unless Congress, on the federal side, expressly states that there is a statutory scheme that falls outside of arbitration, there is no vindication of rights arguments. They also closed the door on a sub-argument that has been developing around the country when state courts say, we find that there's a policy of the state which says arbitration is inappropriate, and therefore, we're going to find a vindication of states' rights argument. Well, if you think about it, that's completely inconsistent with the Supremacy Clause. How can a state court trump the FAA, the Federal Arbitration Act? And that's essentially what the Supreme Court said in the American Express Italian Colors case. So, and Justice Kagan, and again, another smackdown, had a problem with the majority decision in her dissent. She said the rationale of the decision essentially allows American Express to use its monopolistic powers to force a contract term into arbitration and essentially extort on the basis of its monopolistic control. And she said the majority feels that it's just too darn bad. The reason I focus on that is it's a 5-4 decision. And so we've got a split court, and a new judge on that court in our lifetime could make this go a different way. But for now, this was a firm exclamation point on the fact that Concepcion, the decision of 3 years ago, is the law of the land. Binding agreements to arbitrate will be enforced according to their terms. Spend a minute on Concepcion to remind people, what that law meant. Again, another closely divided court. The arbitration provision with the class waiver was upheld as a matter of contract, and it was challenged to California's so-called Discover Bank rule, which said, certain types of claims for class relief are not appropriate for arbitration. And the Supreme Court said, no, sorry. The law, or the FAA is quite clear on its mandate. Valid, irrevocable, and enforceable contracts to arbitrate, save upon such grounds as existent law and equity for the revocation of any contract, is the standard. Now, what does this mean? Let's spend a minute parsing this stuff. Why has this been such a perennial issue? Why are people always fighting over the scope of an arbitration clause? One is because sometimes judges decide it, sometimes arbitrators do, but the other reason is this savings clause. Agreements that are valid, irrevocable, and enforceable is the first phrase, which seems pretty straightforward. But then there's this huge savings clause. Save upon such grounds as existent law or inequity for the revocation of a contract. That breathes life into state law. There is a role for state law on the issue of conscionability. It can't be a circumstance where arbitration is treated differently than other substantive laws, but if the arbitration provision is unconscionable, there is an attack as to whether it's valid. And in fact, it's not just unconscionability, it's fraud and duress. So the new battleground for these things is not vindication of rights, which had been out there for a while, but it's really on the issue of unconscionability. And the Supreme Court put an exclamation point with Amex on the Concepcion holding. When state law prohibits outright the arbitration of a particular type of claim, the analysis is straightforward. The conflicting rule is displaced by the FAA. Pretty straightforward. Shouldn't happen. Again, the areas where, I should mention that after Concepcion, the Supreme Court issued 2 per curiam decisions, which put out very clearly that Concepcion will stand for the proposition that when states try and enact hostile laws to arbitration, they will be displaced. And so The battlegrounds for these issues, whether or not the class waivers, the arbitration provisions you have in any of your customer-facing agreements have been on unconscionability, vindication of states' statutory rights, federal rights by the antitrust laws, which was Amex, or state unfair and deceptive trade practices claims. That middle bullet seems to be a dead letter because of Amex. It's over. And then there's a subset of other claims that are percolating around the courts, which is if there's a public interest injunction, that there needs to be some exercise of the police powers to protect the public, that might be an exception to the FAA. I handled a case last year in the Ninth Circuit en banc, which breathed some interesting help into the defense bar on that. This was the Kilgore case and involved a failed helicopter school and students who did not get the benefit of their bargain with the school, yet had these substantial tuition bills. And national class was brought against several lending institutions. The California class never was certified against KeyBank, and the original panel decision said the arbitration provision was unconscionable, should not have been or could not be enforced simply because in California, under their 17200 unfair competition law, an effort to get a public injunction stands outside the FAA. Now, public injunction became an area over which both sides fought in this thing. And what happened after the Kilgore decision is many complaints just came out with contract claims that said we're seeking a public injunction. And what the Ninth Circuit said is you just can't call something a public injunction and expect us to believe it's the case. If you've got issues of individual contract and the relief you're seeking has to do with those individual contracts, there is no public interest available. And so we're not dealing with a public injunction exception. The public will not be benefited. The relief is based on contract, and if there's an agreement to arbitrate, it will be enforced. Why do I pause and say that? This is a practice point to share with all of the counsel that are working on these types of claims for you. To the extent you have plaintiffs' lawyers contending that the relief being sought is public in nature, benefits the community at large, as opposed to vindicating rights on the contract, this case stands for the fact that that will not fly. I think what I'd like to wrap up with is that the last part of the battle that I think all of you will be contending with is whether or not the arbitration provisions that you have in your contracts are unconscionable. So what does that mean? Are they contracts of adhesion without opt-out provisions? Are they so one-sided that the contention is that there was no material choice in the marketplace and therefore a state law judge, or applying state law, it could be deemed unconscionable? Amex 3 stands for the proposition that regardless of what it would cost to vindicate your rights in an arbitrable forum, that will not be a barrier to arbitration. As long as your arbitration provision provides a forum to vindicate a right in arbitration, whether it's too costly or one-sided, is not going to be found unconscionable. And that's significant because for the past decade, most of us have had to talk with our clients about finding ways for opt-out provisions, finding ways to make the arbitrable forum in equal footing to the public forum, so you'd pay for certain expenses associated with arbitration. Sometimes you'd pay a bounty to the plaintiffs if they simply comply with their obligation. Amex may stand for the proposition that that's no longer necessary. So I said at the beginning, it's a new day, it's a new game. Everybody who's got an arbitration provision with a class waiver should look at that anew. Through the lens of Amex, through the lens of Concepcion and the cases that have been decided, if that's a viable strategy for your businesses, for your clients to get this scary, business disruptive, high exposure class problem out of court and in arbitration, the Supreme Court is going to do it if you've got the right instruments. Thank you very much for your time and attention.